All rise. The Minnesota Workers' Compensation Court of Appeals is now in session. The Honorable Catherine Carlson presiding.
Welcome, be seated. The case now at hand is file number WC 256626, entitled Danny McClain versus Eagle Intermodal Services, Inc. and Argo Group USA, or excuse me, Argo Group US. As you will see, we have a three-judge panel today. We have Judge Sean Quinn, Judge Tom Christensen, and myself, Judge Kathy Carlson. Mr. Ferguson, I know you have been here before. Ms. St. Germain, I believe this is your first time. Welcome. The timing rules are as follows. You each have 15 minutes total for your respective arguments. We will give you 3 minutes of uninterrupted time to present your argument, and then you will be asked to stop to see if the judges have any questions at that time. Petitioner goes first. You may reserve as much time for rebuttal as you wish. You are in charge of keeping track of your own time. Whatever is left on the clock will be restored for your rebuttal when you come back up. Also, so that you are aware, we are both recording and live streaming the argument. It is helpful to those that are listening who are not in this courtroom if you can both speak up when you're at the podium. Mr. Ferguson, you represent the petitioner. You may proceed.
Sorry, we were playing with this earlier.
Some people never figure out how to do that.
I was one of them. Very good. May it please the court and counsel, I'd like to reserve 5 minutes for rebuttal purposes. We are here on regards to Mr. McClain and Eagle Intermodal, as you identified. My name is Aaron Ferguson. I represent Mr. McClain. This is going to be a complicated case. It involves a lot of complicated issues, so I'm going to try and make as the wind blows with the issues and call out what appear to be the most pertinent parts in this case. Obviously, we're here on a petition to vacate. That's the relief we're asking for, is to vacate the awards in this matter. But we have to address really the call of 176461. Two issues. One, did we, as parties, clearly anticipate the condition? And I would just point to the plain language of the stipulation because there's no mention of CRPS in it. The stipulation in 2011 also clearly denotes that there's no mention to all the other body parts we are here to address since the award was issued back in 2011. So as a practical matter, it seems to me that if the parties put in a settlement document what their present state of mind is, and that present state of mind doesn't talk anything about what we're here to deal with today, it seems to me the first prong of, was it clearly in anticipation of the parties at the time of the settlement? The answer would be no. If it were, all the stuff that was discussed by respondent in their brief and the various medical professionals clearly would have ended up into the stipulation for settlement in 2011, and it's not there. What is, however, in there is references to alleged consequential injuries at that time, the left hand, wrist, and shoulder, and the gastrointestinal issues. And I may have misspoke. I think it's just limited to the left hand and wrist and the gastrointestinal issues. If it were clearly an issue in which the parties contemplated the CRPS, again, it would have been in there, and the respondent didn't put it in there, and they're the drafting party of the stipulation for settlement. Second thing, the next part of the requirement under 461 is reasonably in anticipation of the parties. And this is going to be where we get into a line drawing contest about what the state of medical knowledge is. We have, appears to be 10 separate medical opinions in this case, and by my estimation of reading, rereading, reading again, falling asleep on these reports, trying to come up with some magical summation, none of them agree. So we have Dr. Gadam, Dr. Husband, Dr. Falconer, Dr. Sipple, Dr. Sager, Dr. Koch. I mean, there's a litany of doctors in this case, none of which I would submit to this court are unqualified. They're all extremely competent experts in their field, and yet none of them necessarily agree on the scope of the injury in this case. So it's time to play doctor for all of the parties that are here, because that's what we do in a highly specialized court, just as this court is and as the trial judges at the Court of Administrative Hearings do. And that is, we have an issue pertaining to an orthopedic injury of a TFCC tear that was present in the right wrist, confirmed via MRI, confirmed via surgery, not once, but twice, but 3 times, And that's where we get to this, because the orthopedic testing completed in this case initially identified by Dr. Husband.
Mr.
I
Ferguson.
just ran past my time,
Yep,
so I got
nope,
to stop.
sorry, I was kind of keeping an eye on it, thinking you were going to end naturally, but I'm just going to stop you there because I know that we all have a lot of questions.
I had to take a breath too.
Yeah, understood. So I'm going to ask the judges if they have any questions.
Yeah, I have a bunch, and I guarantee you we're going to get you over your 15 minutes, probably for both of you. So,
And
Very good.
So be
There
it.
is equal time.
Yeah.
If Mr. Ferguson goes over, we add that to your time.
and I'll preface this by saying this is a petition to vacate. This is a court of original jurisdiction for that. So the record closes when we say it closes, as opposed to an appeal where our record is static. So the first question I have is just more, I don't know what you would call it, procedural for you, Mr. Ferguson. You reference an employee affidavit in your petition and your brief. And I assume that that has been served on defense counsel. Do you have the employee's affidavit, Ms. St. Germain? I hate to go to you, but do you have that affidavit of the employee? It references an affidavit. So is there an affidavit?
There is.
Okay. We don't have it. That's
Yep.
why I ask.
All right.
And so if there's an affidavit, I'd like it, and I'd like to make sure defense counsel has it and also has an opportunity to respond to it if they haven't received it. I understand there's a pending claim petition. We don't have access to the CAH filings. But what is the status of that claim petition?
It's on stricken status pending the outcome of this, this petition to vacate, which I think you're getting to is
Yeah.
why wouldn't we just send it down to the trial court to get findings on the causation prong, which is obviously an issue of debate between the parties.
Well, that is a subsequent question I have, which is one of our options, of course, is to not necessarily decide the petition yet and refer it down to CAH for some findings, which would be appealable. Findings on a claim petition would also be appealable. Is that something that you think we should do here?
I think that's a judicious way of viewing this to try and avoid having us come back. Now, here's the rub, though.
Go ahead.
Yeah, so let's say you send it back down and the employee prevails on a number of those claims, which include the arthrodesis procedure, the shoulder surgery. Let's say that all happens. Do we not then beg to come back here and do this again? Or do we go back and do it one time with a vacation in place and we try all the issues one time with the trial court?
Well, and the question is, could the CAH judge even merge the two things into one, a referral and the claim petition into one hearing? I can't tell CAH how to do their job. They might even assign it to two different judges, which then creates a whole other set of problems. I assume they wouldn't do that, but I don't know what they're going to do.
I don't think they would, but I think that that could be done simultaneously, and I think there's authority for it in the statute to do so. So I think that is a viable option here today before you.
All right, so let's assume hypothetically we decide we're not going to vacate, but we are going to refer. What kind of questions do you think need to be answered here? I assume causation of the CRPS is one of them. Well, is there CRPS is one of them? Causation is a second one. What else?
So if we, reasonableness and necessity of the arthrodesis surgery, which is already before the court, the right and left shoulder issues that have been identified. And I think from a practical perspective, I even hate to bring this up because it gets into another factor, which I don't think we're there yet, but is to have potentially a vocational assessment to find out whether those things change the relative labor analysis for Mr. McClain.
Okay, well then that begs yet another question, which is
Sorry.
at the,
Should
well,
I-
no, that's fair. I was
first.
going to ask it anyway, so
Okay.
it doesn't matter. So when the case settled originally, it settled for a fairly substantial amount of money, which at least tells me that PT was on the table at the time. And in fact, the party stipulated that your client was permanently and totally disabled as of a certain date, and the Social Security language was in there. Your client had a pending application for Social Security, which I understand was subsequently granted, wasn't granted at the time of the settlement. If it seems like PT was contemplated by the parties in reaching the settlement agreement. Can your client be more PT? I can understand your client being in more pain, but can your client be more functionally unable to work?
I think this is absolutely a wonderful question. So let's answer it in this fashion. At the time, we're looking with hindsight, right? So
Yep.
at the time, he was 39 years old, about ready to turn 40 at the time he was injured. He exhausted his temporary total disability. He was found in himself he was in a donut hole, if you will, between the exhaustion of temporary total disability and permanent total disability, and relatively young with a relative high wage, if we look back to that time period. So the question is the contemplation of the substantial settlement in relation to a very prolonged vocational future, which vocational services can be quite expensive, is that in contemplation of retraining benefits? Is it in contemplation of permanent total disability, or perhaps some combination thereof? When it comes time to settlements, people are always involved in horse trading because no one knows what the future is. If we all knew what the future was, none of us would be here, quite frankly, and I would not get the chance to see your shining faces. But be that as it may, can you be more PT? Well, perhaps you can. And in this case, as the medical records bear out, in 2023, and throughout his employment and his own deposition testimony, he has actually gone on to obtain certain forms of employment, but never been able to maintain substantial gainful employment that is repetitive and consistent with the framework. So that therein lies the rub. He may not have been permanently and totally at that time. Social Security certainly eventually found that he was, but we don't abide by that standard. And under the statutory framework for permanent total disability, his age, aptitude, skills, and those factors, no one was at that point agreeing that he was permanently and totally disabled. And in fact, the 2011 stipulation clearly says that, which leads me to this question. If on the one hand, they say that the genuine dispute at that time was he's not permanently and totally disabled, and then they agree he's permanently and totally disabled, do we not have an internal inconsistency in the stipulation? So
Well, there's a difference between these are our allegations and then this is what we agree to.
well,
You know.
precisely, but then we get to the contemplation of the parties, right? And
Yeah.
no one knew what his future was at that time.
Yeah. But I mean, it seems like whether he was or was not entitled to permanent total disability benefits was contemplated, not necessarily agreed to, although ultimately agreed to that status in the stip, but it seems like it was thought about. That's
Well-
what contemplated means to me.
Oh, sure. And I think that's in every stipulation, every full final closeout, there's a contemplation of that potential. The difference here being that the settlement wasn't an insignificant sum of money, which I grant, totally grant that. But he was a relatively young person at that time with a very prolonged runway in front of him.
Okay. Okay. Then the other thing about the reasonable contemplation is there's certainly some medical evidence, and I think it is relevant, before the settlement that your client had some complaints of shoulder pain, at least on the right, and some neurological symptoms that may or may not have been called RSD at the time. The defense argues, I think, at least reasonably, that was contemplated. It was thought of. I mean, the parties knew about these things. Why should we say that those things were not contemplated?
Sure. So I get back to the statement that is always thrown in my face by independent medical exam doctors when I depose them, and that is not all hoofbeats are zebras. Oftentimes they're horses. And so in this case, when you're going through the diagnostic phase of care, simply because you present with a symptom and a potential list on the differential diagnosis list of outcomes doesn't mean that everyone's contemplating that. And this is where I was ending off when I left this, or when I was asked to leave this open for questions, because Judge Penny Johnson made a incredible set of findings and orders in this case related to identifiable orthopedic testing for an anterior posterior interosseous nerve injury, which is why he went on to have the interosseous neurectomy, right? And those things are very specific. Those orthopedic tests are consistent with the peripheral nerve system. CRPS is a horse of an entirely different color, right? Because it pertains itself to the parasympathetic nerve system. And I know we're getting very granular here, but your question is well noted, because if that symptom is possible of being put in other boxes, it still doesn't complete the picture as to what everyone understood at that time.
Well, Mr. Ferguson, do you mind?
Go ahead. No,
Okay.
go ahead.
I'm glad we're talking about the CRPS. First of all, not everybody agrees with the diagnosis, correct? Not everybody agrees that your client has CRPS.
100% correct.
My question for you is, if he does have CRPS, is that a consequential injury or is that a change in diagnosis?
So it depends on which doctor you go with, because some of the doctors seem to suggest it's an original injury. Some have opined that it is a late stage development as a chronic nerve irritation issue. One of them would be an original injury. The other one would be a consequential injury. Dr. Sager says it's a consequential injury. Several of the others say it's type 1 CRPS. There's even some postulation that it's a type 2 CRPS. And so those all have different pathophysiologic explanations.
And do you feel that our decision is at all affected by whether it's a change in diagnosis or a consequential injury?
If things were different, they wouldn't be the same. Maybe. I mean, that's a extremely hard question for me to answer, because I think on one hand, it fits under the fondness rubric. On the other one, it does not. And we deal with a Ryan versus Potlatch analysis. So
what is your gut instinct? Is it a change in diagnosis or is it a consequential injury? Or do you think that's a significant fact issue for a lower court to consider?
yes, yes, and yes. Dr. Ferguson thinks that it would be best if you issued a referral back for a determination on those factual issues.
And then my other question on the CRPS, it looks like, I believe it was Dr. Sipple that gave a permanency rating, but do you agree it's kind of an incomplete rating? It's not a real solid rating.
There is some want for it because it seems like it may be under a different set of rules.
Okay, all right. I just wanted to make sure we were all on the same page with that.
And I feel this big right now.
Well, he said 50%, and
Correct.
it's 50% of a body part, and then you go to the amputation section, and there's a variety of different choices in the forearm, but they're all pretty high.
Yes, I think that's correct, but it's a percent of the limb
Right.
amputation schedule. Yes.
Right, yeah. So it's
But-
50% of whatever that is.
And it would be difficult for us to determine without some medical guidance as to what the amputated body part would be under 0540.
That's
right?
correct.
Okay.
What the underlying facts are in this area need really to be nailed down, I think, to answer some of these questions. I know my time
Keep going.
disappeared before my
Yes,
very eyes.
I'm
it
done.
vanished.
We- We'll just keep you here for a while. I just want to go back to, medical was left open, which is one of the factors, but one of the things that I saw during the deposition, which was 8 years ago of Mr. McClain, your client, what medical has been paid, if you know, up to the time since the stipulation for settlement related to the injury, and what medical remains unopened related to, first of all, the right wrist that was left open, if you're kind of following me.
I am. So if you look back at this, in our brief, we made a notation of this, that since the employer insurer doesn't want to pay for anything, that lack of payment has been ongoing for quite some time now. And their doctors have largely opined there's nothing to be done with him. In fact, we would submit that Dr. Donovan's, I think between his two reports, he's over 300 pages of IME reporting, which quite frankly, I've never really heard of or seen until this case, but he seems to suggest there's really nothing to do of anything. And so none of his stuff is being paid for, even the chronic pain treatment that he's undergoing, to my understanding. I'm pretty sure, because I've seen the bills, that even Premier Pain's treatment hasn't been paid for.
So it's safe to say, at least from the evidence that we have in the record, little, if any, medical has been paid since the time of the stipulation to the present time, even though medical was left open.
Yes, I think that's right. I think the things really got limited in 2016 is when they really stopped paying for treatment. And I think that's where we sit currently.
Anything
Was
else?
is it remaining unpaid or paid by like Medicare, for example?
Oh, it's Medicare.
Okay.
It is health insurance.
So there's a huge Medicare intervention claim potentially.
I don't know about huge, but yes, I would say
Okay.
there is definitely some.
Okay. I have another question in light of one of your other comments, because I was hoping we wouldn't have to talk about it, but you said it. Ryan v. Potlatch. No, I know. I thought about this ahead of time. I printed it off. I'm ready for Ryan v. Potlatch. I don't have any qualms saying this. I think I said it in a dissent or a concurrence once. I don't get Ryan v. Potlatch at all. Ryan v. Potlatch is a consequential injury, but they use the petition to vacate language in that decision. And in that case, they said the better bet is for the employee to do a petition to vacate, although they also said that they're not going to grant the consequential claim because it's consequential, which doesn't make any sense. But neither here nor there. How does Ryan v. Potlatch affect your current claim petition and this petition to vacate, and maybe a sequential analysis of how we should deal with it?
I don't love Ryan versus Potlatch, and frankly, I don't know of anyone who does. But in this context, we have to, one, go back and interpret the language in the stipulation. Consequential injuries were left open, but left open for what? And in this case, it's a very limited, finite set of consequential injuries because it's to the left hand, wrist, and arguably the shoulder and gastrointestinal issues, not CRPS, not right any of the other things, the right shoulder surgery. Those aren't even mentioned in the stipulation. So under Ryan versus Potlatch, it would seem to me that if it's not expressly left open and derived or derivative of, then the petition to vacate is the option we have to follow. I'm not sure I agree with that in 100%, but you asked it, and I was thinking
No.
about it because I actually brought it with me just in case you guys were going to ask me about it.
Yeah.
Anything else?
Okay.
Nope.
No,
Um,
no.
Mr. Ferguson, you had asked for 5 minutes for rebuttal. We'll give you 3 minutes for rebuttal. And so, Ms. St. Germain, what that means for you is an extra, if I'm doing my math right, instead of 15 minutes, you'll get 22 minutes. Okay, and that then gives Mr. Ferguson 3 minutes for rebuttal. And understand, just because you have 22, you don't need to fill it, but you'll have plenty of time to answer our questions. You may proceed.
May it please the court and counsel. My name is Sydney St. Germain. I'm here on behalf of respondents, Eagle Intermodal Services and Argo Group US. First, I want to emphasize that the petitioner received over $200,000 combined with the two stipulations. In today's money, that is approximately $288,000. Petitioner had invested that money, it would have been even more substantial sum. Very few workers' compensation cases settle for such a large amount, especially when future medical benefits are left open, and especially when it was assumed that he would be receiving Social Security disability benefits on top of that, and that is what ultimately happened. Key point here is whether the petitioner's condition has worsened as compared to the time of settlement, and if it has worsened, was it reasonably and clearly anticipated? Functionally, the petitioner's condition hasn't changed at all. Back in 2010, Judge Johnson stated he was unable to engage in many daily activities. It was difficult for him to grasp, twist, hold, and lift objects, push with the right hand, and even steer a steering wheel. Grasping eating utensils and writing with a pen were very challenging. And then the petitioner underwent a 2-day functional capacity evaluation in March 2011. So that was only 4 months before the stipulation. Dr. Falconer noted the petitioner functioned at only 1 to 2 pounds occasional lifting and grasping on the right. Then if we compare that with Dr. Sippel's observations in December 2023, when he performed an IME on behalf of the petitioner, Dr. Sippel observed that he had trouble performing simple tasks like holding a coffee cup or a pen in his hand, and he reported an inability to write and turn keys. Those are essentially the same findings, though, and observations made 13 years ago. It's debatable that his condition worsened at all, and we argue that it hasn't. His work status hasn't changed at all. At the time of the stipulation in 2011, he hadn't worked in a year and a half, and he had a pending Social Security disability application. Parties stipulated that he was permanently and totally disabled since January 27, 2010. Meaning the parties contemplated that he wouldn't work again or that he would have trouble finding work. And that turned out to be true, as the petitioner admitted in his briefs that he has been able to do some occasional work for a racetrack and can't maintain any other employment. The biggest problem here for the petitioner is that he has failed to prove a causal relationship between his alleged worsened condition and the work injury. Nothing has stopped him from pursuing medical benefits over the years for disputed treatment, and in fact, he and his attorney did file a claim petition in 2017. He has had 8+ years to prove up causation, but he appears to have abandoned that effort and is now seeking to overturn a voluntary agreement and get a second bite out of the apple. He's failed to satisfy the fairness factors, and therefore his petition to vacate is inappropriate, and we are asking that it be denied.
Thank you, Ms. St. Germain. We'll take a break and see if any of the judges have any questions for you at this time. Judge
Okay.
Quinn?
I kind of asked you when you were sitting there, do you have the employee's affidavit, if you know?
No, I do not, Judge.
Okay. This causal relationship issue that you ended with, Mr. Ferguson concedes that there's the dispute as to this, and suggests maybe this is appropriate for a referral before we even make a decision. Would you agree with that, just conceptually?
No, I would not. I think he would need to reinstate the claim petition and pursue that to resolution.
Okay, so resolve the causal issue in the claim petition.
Yes.
Okay, and the pending claim petition is seeking, as I understand it, medical benefits. Okay, that's the only thing being sought right now.
I believe so, although I do think he may have also been seeking rehab benefits and other indemnity benefits, which we denied based on the prior stipulations.
Okay, so assuming that the stip closes those things out, which I think I would agree with you, that seems to be exactly what it does. There's medical benefits for all the various body parts that Mr. Ferguson's talking about, left and right, wrists and shoulders, CRPS, and I think even the neck might be involved at this point. Maybe I'm misreading that, but let's assume hypothetically we were to refer it and a comp judge says, yes, this man does have CRPS, and yes, it's causally related to the original right wrist injury and the subsequent surgery. Does that change your argument on substantial change?
Well, I think the second part to that argument would be whether it was reasonably anticipated. And so we would argue that for CRPS, that it was reasonably anticipated because there were diagnoses by providers prior to the stipulation.
Okay, and those I think you referred to those things in your brief. There was some mention of some RSD, which is just an earlier name of pretty much the same condition. Is there anything beyond what's in your brief there?
No, primarily relying on Dr. Cook's diagnosis of that back in 2008. And that was specifically incorporated into the stipulation under the employee's claims and contentions. It was pointed out that they were relying on medical records from Dr. Cook. So I do believe that that was understood by the parties, that that was a potential diagnosis.
Okay. Now, the work comp law is just a general conceptual thing, and there's some Supreme Court case law that says this in probably much better language than I'm about to say, is we want to make sure that the employee is reasonably and appropriately compensated for the work injury that he or she may have suffered. And that seems to be, and I'm paraphrasing, and he can correct me on rebuttal if I'm wrong, it seems to be that that's Mr. Ferguson's argument. The crux of it is this man he's got this horrible condition, and we really weren't thinking about this horrible, horrible CRPS condition. And again, we're going to assume causation and all of that. And if the goal is to reasonably compensate an injured worker, is there a danger if we don't grant this petition to vacate by, not giving this man fair compensation? Again, I'm assuming causation. So
I do think the settlement sum back in 2011 was substantial compensation. And again, that was with the assumption that he would be receiving Social Security disability benefits on top of that. So I do think it was a substantial sum back then. It's a substantial sum even now to compensate him for his medical treatment, for all the indemnity benefits. And medical benefits are left open.
And that goes to my question that I asked Mr. Ferguson. Do you have some kind of idea what payment history, because it's not in the record before us, as to how much medical has been paid by your client since the time of the stipulation for settlement?
Yes, and we didn't include that as an exhibit. We probably should have, but I did print out a itemization of medical benefits. My client did continue to pay for what we deemed reasonable and necessary medical treatment after the stipulation, and the itemization I have is through July of 2021. So benefits continued to be paid up through that date. So yes, we did continue to pay benefits.
So at least through 2021 or
Fine.
July of 2021, not known for the last 4 years or something like that. And I assume those medical payments, and probably have it in front of you, we don't have that, are for the right wrist and hand then?
Yes, they are.
Ms. St. Germain, you indicated that Mr. Ferguson and his client would need to pursue and prove up the causal connection at the lower court. What body parts or diagnoses do you feel need to be addressed by the lower court?
Definitely CRPS, whether that is in fact correct diagnosis, whether he has that. The left wrist cartilage tear, there's been some differences of opinion in the medical records, even from his own providers, whether that is related or not. The right shoulder, the rotator cuff tear, the employee's provider noted that wasn't work-related, but IME providers have noted differently. And then the right wrist, I believe he's been recommended for a wrist replacement surgery. We deny that that is reasonable and necessary based on our own reports, but
So you agree that there are some significant factual issues to be determined?
yes,
And it sounds like you agree that that should be done at the lower court.
yes, I do.
So does it really matter if it's a referral from this court where we could ask specific questions, or that the petition to vacate is just dismissed and Mr. Ferguson and his client could file whatever they like? Does it really matter?
I think it's going to end up at the same place, but procedurally, I think it does matter that the petition be dismissed because it is premature and he has a claim petition for medical benefits, and he should pursue that, and he's had 8+ years to pursue that, but hasn't done so.
So if it's premature, and let's say hypothetically, Mr. Ferguson's client is successful proving up the CRPS, the left wrist, the right shoulder, for all the medical that he's seeking, including causation, then he could file the petition to vacate. You would still have the reasonable contemplation defense. I understand that. But that's the procedural avenue you think is the better course.
I do.
Okay. All right. Then there was one other question I was going to ask, and it was something that you said, and now I can't find it.
While Judge
Go
Quinn
ahead.
is looking, I have a question. At some point in time, Mr. McClain sounds like he received Social Security disability benefits. Do you know approximately first, when he was deemed to be eligible, and two, what he may be receiving at present in terms of benefits?
I'm not sure when he was deemed eligible. He testified that he started receiving it in 2012 or 2013. And I didn't see any mention in the deposition transcript as to an amount. So I can't answer that regarding the amount.
Thank you.
Judge Quinn, did you find a question?
No, maybe I was thinking about something else.
I don't have any further questions, but you still have time on the clock if there's additional things you wanted to discuss.
I'll reserve the rest of my time. Or-
And the respondent does not get rebuttal.
Oh,
So
sorry.
you can use it now, or you can have a seat.
I think that's all for me.
Okay, I'm gonna, before you sit down, I didn't think of this, but I'm gonna ask Mr. Ferguson about it because I forgot to ask him. And so I'm going to give you a chance to talk about it. Mr. Ferguson petitioned to vacate two settlements. The original settlement and also the subsequent settlement that I think dealt with penalties that were later assessed. Is there any reason that you can think of why that penalty stipulation is on the table here?
Not really, besides the fact that maybe the penalty claim is dependent on the prior stipulation.
Okay. Sort of like a completeness thing, but
I
okay.
assume so.
Okay. All right. Fair enough.
Judge Christensen?
Nothing. Thank you.
Thank you very much.
Thank you.
That's question number one.
Yep, I think we agreed 3 minutes for rebuttal. Thank you, Lisa.
There we go.
Whenever you're ready.
I can go whenever, but to answer your question, both stipulations were sought to be vacated for completeness. That is precisely the issue, because they do reference one another and they are sequentially in order. And so it always leaves this unanswered void when you do one, not other. And then the question is, well, why didn't you do both? Well, just to be complete, so there's no ambiguity in it. I want to get back to some really critical stuff here. And I think we're getting lost on a couple points. One, we have a change about PT, right? That issue is whether it was contemplated or not, right, is a factor. But so too is the change in disability rating. The change in disability rating in this case would equate lots of money, significant sums of money that would be hyper relevant to Mr. McClain. And so when we talk about the policy objective under 176461 is to arrive at fairness towards the injured worker and benefits they would otherwise be entitled to, there we have it. I would also look at the soft medical closeout in the stipulation pertaining to nursing services and nursing care. It seems, regardless of whose opinion is ultimately adopted, everyone is indicating that at this point, Mr. McClain has lost function and use of both hands in large order with significant objective clinical problems. I think we all can appreciate that if you lost functional use of your hands, both of them, that you would have quite a different life than you would if you were able-bodied relative to both of those. So I think there are some other issues that bear out consideration in this case. This Ryan versus Potlatch thing is giving me all sorts of consternation. The problem with it is this, is that what is clearly in contemplation of the parties at the time versus not, we could have that debate for, a million years, because the parties don't actively disclose and they don't actively ruminate about that towards the court when we put together a stipulation for settlement. And so on the one hand, we have ourselves, you got to do the petition to vacate. On the other hand, the age-old question is, do you go get an underlying determination first and then seek the petition to vacate? And so we find ourselves in somewhat of a judicial polycentric problem. Do you do both? It's almost like we could have an auction here, because I got the impression from everyone in this courtroom that there's a varying opinion on which way is the best way. And I don't know there's a clear answer to that. And that is why I think we're here. We have ample expert opinions in this case, both sides. But it seems out of judicial economy to do that, to have it referred back so we can have a consideration of those issues and then come forward if we need to at that point. I think that those are completely eminently reasonable approaches in this case, and we would submit that that is a reasonable option in this case.
And two questions before I forget. Do you know how much Mr. McClain is receiving at present, even in terms of Social Security disability benefits per month?
I don't right now. It's been a minute since I've reviewed that, but
And then also, it sounds like medical was paid by the employer. There's some payment history up to July of 2021. Do we have any idea how much Medicare may have been has paid in terms of medical benefits on behalf of your client since whenever he became eligible to the present time?
I don't. I would be curious to see what that itemization shows, because I don't think a lot of his medical care has been paid for. Because Dr. Donovan's reports and Gadan's reports after the stipulations specifically didn't identify any treatment was appropriate or reasonable at all. So to the extent that there's coverage for stuff or items they've paid, they didn't pay for the shoulder surgery, they didn't pay for the follow-up care, they haven't paid for the chronic pain care. I mean, there's a long list of things they just won't pay for.
Okay, but it is being paid for.
Yes,
just
just
not by the defense It's paid Medicare or whoever might be paying it.
Yeah, that's
Okay.
correct.
All right, so your client's not being denied medical treatment.
I don't believe so, but I know the bills. My client has sent them to me.
All right, so there are actually unpaid bills.
I think there are actually unpaid bills
Okay.
at this point. And
Fair.
because he's caught in the whipsaw between health insurance versus work comp.
Yep, I know that story, so.
Thank you,
okay.
Mr. Ferguson.
Thank you, everyone.
Before.
Right. So I think we learned that the employee's affidavit, although it's discussed in your petition, was not filed on campus. Can you do that in the next couple of days and
Do that
make,
immediately. I thought we had taken care of all the exhibits.
I know there were filing issues with the thumb drive and everything else. So yeah, if you can do that, have your office do that in the next day or so and make sure that defense has a copy as well.
Yeah, that'll be done
Okay.
immediately.
Anything else?
Should they have an opportunity to respond if they haven't seen it?
How about this? Ms. St. Germain, if you see the affidavit and if you feel that you would like an opportunity to respond, if you could file a letter addressed to our court asking for whatever time frame you feel necessary to address the affidavit, since it'll be the first time that you see that, and then we will respond to that letter. Okay, so what I say next might change. Thank you both for your respective presentations. Excellent work, both of you. The record is now closed, save for receipt of the employee's affidavit. And Ms. St. Germain, any requests to respond to that, we may leave it open past that. And then a decision will be issued within 90 days of today's date unless we leave the record open a bit longer. I hope that was clear. Thank you very much.
Thank you.
All rise. Court is now adjourned.
Excellent.